Hello everyone, welcome to Ashcroft TV. My name is Kalen Ashcroft. Thank you very much for watching this video on Guide to Legal History and Historians, where we will be covering all of the chapters of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. This happens to be the second last episode of this series, but if this is the first you're watching, thank you very much regardless, and please note these do not need to be watched in order, because although this is a series and a textbook on legal history, it itself is not in chronological order. So if these two topics perhaps hopefully interest you, then you're in the right place if this is your first time, second time, third time, or 28th time, perhaps, or even 29th if you're watching this in the future and have seen the last one. This is also the last complete episode because there's an odd number of chapters, so the next one will actually be slightly shorter. So I'm very grateful that you have supported me this far, and very proud of all the work that perhaps we've done together in terms of research. So without further ado, this is episode 28 of the Oxford Handbook of Legal History. It is in part 5 of the textbook titled Illustrations, Doing Things with Legal History. These will be chapters 55, titled Adjudication of Indigenous-Settler Relations by Richard P. Boast, and chapter 56, Cultural Genocide, Between Law and History, by Leora, Bilsky, and Rachel Klagsbrun. So, and in the style of Plutarch's Lives, there will be a comparison of the authors at the end to learn a little bit more, and there will be biographies of each as well. This happens to have 3 authors because there are 2 authors for the latter chapter, but nonetheless we'll compare all 3 to hopefully learn a little bit more about all 3 intellectuals and their respective works. So without further ado, we will begin with the chapter by Richard P. Boast, before we will continue to the chapter by Leora, Bilsky, and Rachel Klagsbrun. So starting with the biography of Richard P. Boast, he is a professor at the Victoria University of Wellington Faculty of Law. He is a specialist in legal history, Maori land law, Pacific legal studies, comparative law, and property law. He teaches these subjects and also taught or co-taught postgraduate courses on New Zealand legal history, law, and anthropology, and the origins of indigenous peoples' law in Spanish colonial empire. His considerable experience in private practice as well as a barrister. He went to court and appeared before the Maori Land Court and the Waitangi Tribunal, which will be the topic, largely part of the topics of this chapter, and on many occasions both as counsel and an expert historical witness. He has a Master of Law from the Victoria University of Wellington in New Zealand, a Master's of Arts from the University of Hokkaido in Hamilton, New Zealand, and he has the OMNZ, or KC, conferred by the Governor General in New Zealand. He has, as well, he can speak Spanish, or supposedly Latin American variety, so where he can read, speak, and peer review in this language. In terms of French, he can read, write, speak, understand, and peer review. And in Portuguese, he can read and peer review, so quite gifted with languages as well. He's currently working on a large-scale project of publishing a critical edition of leading judgments of the Native and Maori Land Court. Volume 1 was published in 2013, which covered 1862 to 1886. Volume 2 was published in 2015 and covered 1887 to 1909. And Volume 1 was in fact the co-winner of the award for Best Law Book Published in its year. It's quite a significant award. Volume 3 is taking the history of the court to 1953, and was published in 2019 and won award for the best book on the New Zealand law published in its year as well. He's also wrote Buying the Land, Selling the Land, which dealt with Maori land, the Native Land Court, and government from 1865 to 1920, and was awarded the Montana Book Award for History. And he's also been involved in, as far as I can see, 9 books total, so very quite a prolific writer as well. Not to mention all the countless articles as well he's written. In 2015, he was appointed Queen's Counsel, which is now King's Counsel, unfortunately with the death of Queen Elizabeth, and not unfortunate that King Charles is reigning, but unfortunate that Queen Elizabeth has passed away. and who was appointed Queen's Counsel in recognition of the contributions to New Zealand legal historical scholarship. Makes sense, he's been in the Oxford Handbook of Legal History here, and he was made an officer of the New Zealand Order of Merit, that was the ONZM previously referenced, in recognition to his contributions to scholarship in the work of iwi, which means tribe in Maori. So, without further ado, we will move to the chapter itself. So, the title of this chapter is Adjudication of Indigenous-Settler Relations, and it's in Part 5 of the Oxford Handbook of Legal History, titled Illustrations Doing Things with Legal History, and it is Chapter 5 of the Oxford Handbook of Legal History. So Section 1 is titled Settler Societies. So this chapter, according to the author, is concerned with the connections between the field of legal history and the various ways in which claims against states by indigenous groups in the present day are adjudicated and resolved. The focus of the chapter is on indigenous and settler relationships, and thus on legal processes in settler societies. But the latter term has its uncertainties. What are settler societies? Most commentators, according to the author, using this term would have in mind those parts of the world settled by European immigrants in the 19th century, notably the US, Canada, Australia, and New Zealand. These four countries, according to the author, seem to have certain features in common. The importance of the 19th century rural settlement of English-speaking migrants in all four is undeniable, but no less striking is the ideology of settlement, not only historically but also in the present day. In art, historiography, and literature of all four countries, the image of the white settler frontier in the national psyche has loomed large historically and continues to do so. Nonetheless, some difficulties in confining settler societies to these four countries. There were many other frontier European settlements that we shall discuss. Not obvious is why South Africa should be excluded from this group. For example, although its first European colonists were from the Netherlands, it too was part of an expanding British colonial world in the 19th century and developed some important methods of adjudication of indigenous settler relations today, using special tribunals which have many affinities with the native title tribunal in Australia or New Zealand's Waitangi tribunal, which we shall discuss. The only real difference between South Africa and, say, Australia is that the former, the settler community, never became the majority population. It's not necessarily a criterion, however, of difference that makes any logical sense. The other standard examples of settler societies are Argentina and Uruguay, also countries where agrarian frontier looms large in historical economic importance and the national self-definition. But to see Argentina as a settler society and Colombia and Mexico as not implies a distinctiveness about Argentina within the overall framework of the Latin American history. Although Argentina was a long-established colony and Buenos Aires became the capital of a viceroyalty in 1776, nevertheless, Argentina, along with Uruguay, is usually perceived as an essentially 19th century construction compared to older colonial societies such as Peru and Mexico. Argentina and Uruguay therefore took national shape in the 19th century with a large-scale immigration from Europe, resulting in mushrooming growth of Buenos Aires and Montevideo, both cities which can plausibly be said to have many affinities with other settler capitals such as Toronto and Johannesburg, or Melbourne. He notes these three cities, but all of them are in fact not the capitals, and Toronto is not the capital of Canada, that's Ottawa. Johannesburg is not the capital of Australia, it's Pretoria, or Cape Town, they split their responsibilities, or Melbourne. Johannesburg, Pretoria, and Cape Town are in South Africa, or Melbourne, which is in Australia, which is not the capital of Australia, it's Canberra, rather than with older Spanish-American cities like Quito or Bogota. Significantly, Mario Rappaport and Maria Sioane date the origins of modern Buenos Aires from 1880 to 1914. Nonetheless, large-scale European migration to Spanish America in the 19th century was not confined to the River Plate region. Many went to other countries as diverse as Costa Rica and Chile. The distinctiveness of Uruguay and Argentina is a matter of scale, therefore, however, of self-definition and also of national historiographies. Their well-developed tradition in economic history of analysis and the contrasting performance of Australia and New Zealand on the one hand and Argentina and Uruguay on the other based on plausible view that this group of countries have a number of similarities. Rapid growth in the 19th century, high standards of living as at circa 1900, the importance of British investment, economies based on export of primary products to Europe, a frontier settlement, and displacement of former indigenous occupiers. So I guess my takeaway here is there are many ways of perhaps defining it. Is it just English colonialism? Probably not. Is it just at a certain date, post or pre-1900? Probably not. I think the takeaway here is that all of them should be studied. But other countries as well could qualify, such as Brazil perhaps. While it has a long colonial history, like Rio de la Plata countries, it too received a massive influx of immigrants from Southern Europe in the 19th century. Sao Paulo, the capital of Brazil, once again, Brasilia is the capital of Brazil. Sao Paulo is the largest city, however. Rio is also very large too, which I've been fortunate to visit. Beautiful, beautiful place, but also has very distinct culture. While also possessing a long colonial history is another 19th century boom city, a South American equivalent of Melbourne or San Francisco, according to the author. Certainly a Brazilian frontier and indigenous people were and continue to be displaced, however, so it should still be studied. There has been no shortage of adjudication in contemporary Brazil. There is no justifiable case for excluding Brazil from the class of settler societies. There are other possibilities. Siberia could qualify as a settler country, and so could Taiwan, undoubtedly settled by Han Chinese people where the adjudication of settler-indigenous relations is happening today. The main focus will, in fact, this chapter will be on Australia and New Zealand, but should not be seen as endorsing any kind of narrow approach to the subject. The author suggests what is normally meant by settler societies are societies outside Europe, which today are largely products of 19th century migration from Europe, whether from Southern Europe, which is the Argentina, Uruguay, Northern Europe, Canada, Australia, New Zealand, South Africa, or both, such as the United States. So the takeaway here is, what are settler societies? Pretty much anywhere outside of Europe where Europeans had influences. But even, for example, it could be in the Russian case with Siberia. It's quite different there, and also Taiwan, for example, in China. So settler societies could be seen on many different dimensions. However, we're particularly focusing on Australia and New Zealand for the course of this chapter. Moving to section 2, modes of adjudication. So in many countries, indigenous peoples have made or are in the process of making claims for redress against the states in which they live, seeking outcomes of various kinds for historic injustices. Typically these claims relate to land, but some do not, as in case of the Stolen Generations controversy in Australia, or the tribunal-based claims relating to Maori language and legal rights with respect to flora and fauna in New Zealand. As this chapter is focused on adjudication, the focus will be on court and tribunal-related processes of resolution of indigenous claims. So we're sort of narrowing our focus here once again. So now we've narrowed it down into particular settler societies, and now we're narrowing it down into particularly focusing on adjudication, which comes down to the courts or tribunals. Certainly the case, however, that non-court systems of negotiation and settlement of historical claims can require comprehensive historical research, as in the position of New Zealand. The complexities of New Zealand's institutional arrangements are to be discussed. A further complexity lies within the field of adjudication itself. Broadly, the primary distinction is between adjudication in the ordinary courts of a country using the ordinary processes of legal discourse, of private and public law, of which Canada is a principal example. And in fact, I've worked for some time in Canadian Indigenous law, and there's a lot of things going on here, particularly in British Columbia, or the utilization of the special purpose tribunals set up by particular statutes to adjudicate on historical or contemporary claims. Examples including South Africa, Australia, and New Zealand. A quite different adjudicatory framework occurs when indigenous groups bring claims against their own governments before international courts or arbitral bodies, rather than through domestic courts or tribunals. Typically, indigenous groups report to international courts when their own countries fail to establish trustworthy mechanisms of domestic grievance resolution, although this is not necessarily true. Some Maori groups in New Zealand, for example, have brought claims to the International Convention on the Elimination of Forms of of all forms of racial discrimination committee in Geneva, notwithstanding the existence of the Waitangi Tribunal in that country and the willingness of its national courts to recognize and give effect to Maori legal claims. This chapter will not be considering legal historical research before the international courts or committees, but it is nevertheless important to recognize that these cases brought to such bodies will often require comprehensive inputs from specialists in legal history. So once again, narrowing it sort of down to what are the countries doing domestically through the court and tribunal systems. That's not to say there isn't some interaction with international law, which is certainly true. However, that must be studied separately or with specific attention. Canada, the United States, Australia, and New Zealand are all countries which have a long history of cases being brought of Indigenous plaintiffs in the ordinary courts. The principal problem with the ordinary courts as a form is that cases can become almost impossibly complex and expensive, largely because of the technical rules relating to the hearing of evidence in such courts and the elaborate cross-examination of witnesses. A number of countries have experimented with special purpose tribunals set up by statutes such as the Native Title Act in 1993 in Australia or the Treaty of Waitangi Act 1975 in New Zealand. Both statutes set up special tribunals with jurisdiction to deal with Indigenous claims, such as the Native Tribunal and the Waitangi Tribunal, respectively. In neither case was establishment of these bodies primarily driven by the need to hear claims more cheaply and more expeditiously than ordinary courts, although that was probably seen as desirable. However, the Waitangi Tribunal process is a comparatively cheap process for claimants compared to ordinary courts in New Zealand, partly because it is relatively easy to obtain legal aid as compared to ordinary courts, which also impose substantial hearing fees on litigants. The Waitangi Tribunal, for example, does not. Nevertheless, both countries, such special purpose tribunals, do not exclude cases relating to Indigenous-Settler relations being heard by ordinary courts in these countries, and in both New Zealand and Australia, ordinary courts have continued to play a pivotal role. So, my takeaway here is, for example, in Canada, it's almost predominantly done through the ordinary courts. However, there are tribunals that exist. However, in Australia, and even more so New Zealand, to my understanding, they're more likely to go to these tribunals. But Richard P. Boast notes here that they still often do go to the ordinary court system, but it's often more expensive. And he also notes that that's not the reason they created tribunals, but it was a desirable outcome. Limitations of courts as a means of redress are not only practical, but also legal and constitutional. Courts in Australia, Canada, and New Zealand apply the common law of their respective countries built on foundations of English law, but in each case modified by statutes, constitutional documents, and judicial decisions in their respective countries, the latter sometimes deviating from established English precedent. Alternatively, courts of former settler colonies have to develop solutions of their own legal issues peculiar to their respective countries, of which the statutes of Indigenous peoples is the most obvious example. Canadian and English law, common law, are not the same, for example. Nonetheless, the bedrock of common law, its technique and ways of thinking remain. As will be seen, the High Court of Australia's Mambo decision did not disrupt Australian common law, but rather integrated Australia into a common law framework, drawing on authorities from other parts of the common law world, New Zealand included. But this continual refashioning of common law has its limits. Australian courts have been able to say that the doctrine of native title fits within the fundamental framework of Australian law. New Zealand courts, on the other hand, have not been able to say the Treaty of Waitangi of 1840 is generally enforceable of itself in New Zealand courts, although they have sometimes come close to this. In New Zealand, the issue has been readily circumvented by simple expedient of setting up a special purpose tribunal and directing that body to apply principles of the Treaty of Waitangi to cases that come before it. So different treatment clearly between Australia and New Zealand, which are relative to many other countries more similar than other countries, but they're still rather different, just even based on the timeline alone. Special tribunals set up in Australian and New Zealand were not products of any constitutional or political transition and have no kind of embedded constitutional status. Indeed, in New Zealand, in contrast to Australia, it does not have a written constitution at all. Simply, tribunals are not different in kind from specialist tribunals dealing with, for instance, environmental permits or mining and prospective licenses, and it can be contrasted with their South African equivalents set up under the Restitution of Land Rights Act of 1994, enacted in compliance with the 1993 Interim Constitution of South Africa. Although the Waitangi Tribunal and Native Title Tribunal have some affinities to transitional justice institutions, such as comparison of limited value, given neither Australia nor New Zealand was in any noticeable state of transition with their respective bodies were established, it makes more sense to see the two tribunals as arising from a particular conjuncture of historical and legal circumstances in each country, unique in each case, and indeed the two antipodean special purpose bodies are quite different. In New Zealand, the Waitangi Tribunal can be seen as a response to the upsurge of Maori political activism in the 1970s. The Native Title Tribunal, on the other hand, was much more a response of the particular judicial decision that caused a political and constitutional crisis in Australia. The two somewhat similar societies settled at roughly the same time can produce radically different legal processes, the inherent variety of Indigenous-Settler relations in various countries, and the way in which redress can be provided. What Australia and New Zealand have in common, however, is a sense that redress should be provided and a sufficient political will for redress-oriented institutions to be established. It does not, however, guarantee that such institutions will work well or that they will be immune from criticism, either from those who believe that such was unnecessary in the first place, or from Indigenous scholars who believe that the institutions have been established are inadequate or problematic. Bringing cases within a particular legal framework implies a submission to that very framework and operating within such room for maneuver as it might have. As J.G.A. Pocock puts it, there is a good case for the view that common law has always been an instrument of the individualization of tenure, leading towards the commodification of the whenua, which is Maori for land but carrying a charge of its own, and some substance, therefore, in the radical and post-Marxist charge that, in appealing to the courts, we are placing ourselves in power of a sovereign legislature which cannot reverse its course towards the commodification of rights. So a lot to take it here, but there's many differences clearly between the two. Some are different degrees to which they have strength. New Zealand doesn't even have a constitution too, so it could not certainly be in constitutional law, but nonetheless there's significant deviation between the two. Furthermore, there's also parallels that can be seen with other tribunals, such as mining tribunals or environmental assessment tribunals, too. So those would be valuable parallels to look at. But they're different and, to some extent, driven by some political will, or there needs to be some sort of desire for redress. Moving to Section 3, titled Particular Jurisdictions. So Section A, the Mabo decision and the Native Title Tribunal in Australia. So we'll start with Australia, because it is... we'll call it alphabetical. In Australia, the emergence of a special tribunal is closely linked to a decision of the ordinary courts. The High Court of Australia decision in Mabo versus Queensland in 1992. This case was an application of English common law rules relating to Aboriginal title, previously thought not to apply in Australia on the basis that it was a colony settlement. In Mabo, the High Court of Australia, following the decision of the Supreme Court of Canada in Calder versus the Attorney General in British Columbia, which I worked for in 1973, so I know people who worked on that case, decided the doctrine of Aboriginal or Native title was part of common law of Australia, meaning such title could be recognized and enforced in Australian courts provided that the title has not been validly extinguished. So I think that's fascinating that a Canadian decision holds water, it's legally applicable in Australia. There's no formal recognition of native title by the state was required, as it was an integral aspect of the framework of Australian common law. The High Court did not abolish settled colony rule or doctrine of terra nullius, which is Latin for nobody's land. Rather, it concluded that in settled colonies such as Australia, the common law doctrine of Aboriginal title applied with the acquisition of British sovereignty, and in this way brought Australia into line with the law as it was understood in Canada and New Zealand. It so happened that the plaintiff was not an Australian Aboriginal but a Torres Strait Islander, belonging to an indigenous culture that had a very different political economy from the Aboriginal peoples of the mainland. The High Court of Australia could have decided the case by distinguishing the Torres Strait Islanders from the Australian Aborigines, but instead took advantage of the opportunity provided by the case to restate Australian common law as a whole. The High Court saw Aboriginal title as a burden on the Crown's radical title, or another way, recognition of native title was not incompatible with the sovereignty of the Crown. So, firstly, I think that was a judgment on the judge's part to say, oh, this is to make it apply to all Australian Aborigines, rather than just one specific group that are not, in fact, on the mainland, but also that they do have a certain claim, and it is not incompatible with the sovereignty of the Crown. The much quoted passage of the lead judgment of Brennan J., who saw the native title as deriving from the continued maintenance of the Aboriginal custom law, said, "Native title has its origins and is given its content by the traditional laws acknowledged by the traditional customs observed by the indigenous inhabitants of a territory. The nature and accents of native title must be ascertained as a matter of reference to those laws and customs. Stated when a clan or group had continued to acknowledge the laws and to observe the customs of the group whereby their traditional connection with the land has been substantially maintained, then the title remains in existence. However, when the tide of history has washed away any real acknowledgement of traditional law and any real acknowledgement of traditional custom, the foundation of native title has disappeared. A native title which has ceased with the abandoning of laws and customs based on tradition cannot be revived for contemporary recognition." So, lots of takeaway there. So, that's basically essentially the test for whether there's title. The Mabo decision was a revolutionary event in the legal history of Australia, as until 1992, native or Aboriginal title had in practice not been recognized by either the federal or state governments. Although some states had set aside substantial areas of Aboriginal reserves, complex issues arose as to whether state legislation was incompatible with the law stated in Mabo. The government of the day, confronted with the risk of proliferation of cases against the Crown in the ordinary courts, chose to establish a specialist tribunal given the name of the Native Title Tribunal, set up by the Native Title Act in 1993 and enacted 18 months after the release of the Mabo judgment. This new tribunal was set up to give effect to the native title rights, such rights defined in Section 223 of the Act, and a key provision which has been subject of repeated scrutiny of the Australian courts. Section 223 essentially translated into statutory form the principal components of native title as defined in Australian courts. Tribunal has gone on to make many determinations of native title to particular areas. Cases relating to Aboriginal rights have, however, continued in Australian courts, typically relating to the extent of the Native Title Tribunal's jurisdiction over problematic categories of land, for example, pastoral leases or territorial cedes. The vast structure of the precedent and the academic commentary has been built up since Mabo. So, there's this very significant Mabo case that dates back to the Calder case in Canada, ultimately shortly after the establishment of the Native Title Tribunal to actually sort of implement it. And then even some of the existing agreements had to be reconsidered as well. Moving to Section B, the Waitangi Tribunal in the context of the New Zealand legal system. So now moving to New Zealand next. Of all the settler societies, it is New Zealand, according to the author, that the relationship between the government and indigenous people has been most central to lawmaking and to the national politics. So I say it's a big issue in Canada, not necessarily an issue, a big focus in Canada. It is even more so in New Zealand. The country's history takes its starting point from the Treaty of Waitangi in 1840, a treaty negotiated between representatives of the British government and the Maori people. The document is written in both Maori and in English, and the two texts have some significant differences in meaning. In the 19th century, Maori, iwi, which means tribes, were formidable opponents of the colonial regime, albeit that Maori world was divided in its allegiances with some of the tribes supporting the colonial government. Today, Maori form about 14% of the national population, and many Maori are active in politics, the professions, the media, the arts, and in academia. An indigenous Maori monarchical movement, the Kingitanga, meaning King movement, continues to thrive, although not all sections of the Maori world regard themselves as owing allegiances to the Maori king. Additionally, New Zealand has long had a special court of dealing with the Maori land matter, the Maori Land Court, which originally established in 1865 and also exists a separate system of Maori land tenure governed by a special statutory regime which applies to about 14% of the North Island. Records of the native Maori Land Court in continuous operation since 1865 are a key source of the ethno-historical research in New Zealand and are often utilized by historians carrying out research for Maori groups to support their claims against the government. Maori people were all and are still divided into numerous tribes. Iwi also means bones, which is an interesting. So tribe means bones, but you cannot have just one bone. You need to have multiple. So it's almost necessary to have multiple tribes. Themselves divided into smaller social units in ways which are much too complex to explain here. According to the author, some iwi are very large. For example, some are over 100,000 people affiliated with the Ngāpuhi iwi of the Northland region. So I had a discussion with a coworker once that New Zealand would perhaps not be a good case study for making parallels with Canada because this individual said there's only one nation in New Zealand. But it's divided into many different iwi, and many iwi are very large, 100,000 people, which are larger than the vast majority of Canadian First Nations. So perhaps it could be comparable. The Waitangi Tribunal is another unique component of the New Zealand legal and constitutional structure. It was established in 1975, but it was not significant until 1983 when it released its first major report dealing with an area of North Taranaki. At first, the tribunal's jurisdiction confined to the government's actions arising after 1975, but in 1985 its jurisdiction was substantially enlarged to all acts or omissions of the Crown since 1840. The tribunal's principal function is to issue non-binding recommendations to the state as to whether any act or omission of the Crown since 1840 is contrary to the principles of the Treaty of Waitangi. Legally, it is a permanent or standing commission of inquiry. Most judges of the Maori Land Court, a number of whom are Maori themselves, are members of the Waitangi Tribunal, being legally qualified as they who usually preside over the tribunal's inquiries, but also comprised of many members who, while not legally qualified, may be experts or specialists in other disciplines such as anthropology, history, Maori studies, and linguistics. Bicultural body is also a bicultural body in that many members of Maori Kuamatua, who are elders, experts in custom and Maori language and oratory. Some tribal members, both of Kaumatua and academic specialists, are included as well. For example, or some of these fill both functions, such as Hirini Moko Mead, who is a Kaumatua and an academic specialist in Maori art and Polynesian archaeology. The tribunal's functions derive entirely from statute and the Treaty of Waitangi Act of 1975. Is just an ordinary act of Parliament which can be amended by Parliamentary Act at any time, and has been amended and modified on many occasions. In effect, claims in the tribunal are essentially civil actions by Maori claimants against the state or the Crown, which participates in the process basically as a defendant, so it almost takes the place of a court. Law, however, by which the state is held accountable is not ordinary public or private law, but rather that the principles of the Treaty of Waitangi. So it's governed by the principles of the Treaty of Waitangi. And the Waitangi Act does not attempt to define the principles of the Treaty of Waitangi, and merely requires the tribunal have regard to the Maori and English texts of the treaty, both produced in the schedule of the Act. and has itself had to create the meta law by which the state is to be held accountable, something of an enclosed process. So on one hand, kind of doctrinal, but there's also much room for ambiguity, even just between having in two different languages. The tribunal has been procedurally innovative as well. Claimants hearing usually in groups' own language, Maori, which is a Maori ceremonial center, and there are hundreds all over the country, used for hui, which are meetings, or tangi, which are funerals, and other events. So they're held in important Maori sites, and some in urban areas and others in rural localities. Architecturally, they are impressive as well. They often have kindergarten is hosted there, language nest, and even a kitchen. Each tribunal hearing lasts about a week, and days begin and end with prayers and Maori ceremony. Hearings are open to the public, and in practice most testimony, questioning, and cross-examination, however, is done in English, more or less similar to the other special tribunals such as the Environmental Court as well. Rarely they attract media attention, however, but they do seem to be running smoothly. Their home base, however, is in Wellington, despite this decentralization, and hearings typically are multi-party. Inquiries into all claims in a region, for example, the northern South Island, the central North Island, and the Whanganui region, tends to be a large number of lawyers present. There's always a senior team from the Crown Law Office and many Maori lawyers too. Sometimes there are tensions amongst the claimants. Inter-Maori politics may remain intense, so going back to there's many different iwis and many different subgroups within these iwis who inevitably don't always have the same opinions. It's also time-consuming and elaborate, so it does have its costs. And some seek to bypass or circumvent aspects of it. The New Zealand government at present day is actively engaged in a very active program of negotiating and settling, and there's a special agency with the responsibility of implementing process known as the Office of Treaty Settlement, the OTS, which is a section of the Department of Justice in Wellington, and also a minister of the Crown in charge of the process generally. Historical settlements, although cannot amount to full restitutio in integrum, so more Latin meaning restitution in the original position, and this could bankrupt the state and could be very substantial. The largest settlements range between New Zealand 170 million New Zealand dollars, others in the range of 20 to 100 million New Zealand dollars as well, of a program of large-scale settlements going on since the late 1990s. Settlements with iwi, or at least with a substantial section of tribes, large natural groupings. So there's one discussion that we have in British Columbia is whether the province should negotiate with indigenous nations on a one-to-one basis or with groups. Because, for example, there's this one group of nations and all the nations have grouped together and deal with the province, but one chose not to. So should that nation that left still have the benefits of negotiation, and in fact get greater power on account of leaving the group? So here it seems like they do seem to do it in groupings, large natural groupings they call here. So that's probably a good takeaway here, is that should they naturally be grouped or not. Settlements are partly in cash, partly in land and other landed assets, and partly in the form of cultural redress. The latter could be particular rights of consultation with respect to areas of lands and water in public ownership. One of the largest in the world and will cost several billion New Zealand dollars when complete is the New Zealand government can well afford. Settlements are given the effect by the deed or a written contract. The very long, hundreds of pages, and implemented by Act of Parliament, which gives the agreement unchallengeable legal effect. So although it comes from the tribunal, these agreements are implemented by Act of Parliament. The first of such acts was in the 1990s, the Waikato Raupatu Claims Settlement Act of 1995, and then came the Nagai Tahu Claims Settlement Act of 1998, and now there are a large number. These are considered fully settled and cannot be raised again with the Waitangi Tribunal subsequently. So it's kind of also, when do they want to finalize the agreement under the assumption it cannot be changed. And they're not necessarily linked to health and education initiatives as well, which are clearly important. despite the willingness of not matched to any real inquiry as to the practical results of the process. Probably the most recent important controversy around the foreshore and seabed subject of New Zealand Court of Appeal in 2003 found that Maori Land Court had jurisdiction to investigate Maori land claims relating to land in the intertidal zone and bed of territorial sea, which the idealistic standards of the present day to the actions of the colonial regimes of the 19th century, which have led to the award of the Maori land title in this area. The government of the day responded with a statute extinguishing Maori claims to the foreshore and seabed at common law and under Maori land legislation, replacing former legal options and new processes for recognizing Maori claims to what is now referred to as the marine and coastal areas. The outcome is similar to the Mabo decision in Australia, in that various legal rights and options have been recognized by ordinary courts, recast into statutory framework. Statutory vehicle such as the Foreshore and Seabed Act of 2004 have been widely criticized and replaced by new legislation in 2011 in this example. It's still unclear whether the 2011 Act provides a workable or effective solution. So some of these solutions still are quite contentious over time, and sometimes they need to be changed. Moving to section 4, the role of historians. Hence, why is this in the Oxford Handbook of Legal History? As you might already, however, guess, this is clearly based on history, and without looking at history, I think we'd be quite blind. So, section A, historical research and evidence. The extent to which specialists in legal history play a role in adjudication of settler-indigenous relations turns on the nature of the adjudicatory mechanisms established in various countries and the legal parameters within which such bodies operate. In this respect, Australia's Native Title Tribunal and New Zealand's Waitangi Tribunal are quite different. In Australia, Indigenous groups need to show maintenance of customary practices down to the present day, and the role of historians as expert witnesses in Australia is comparatively limited. Expertise is required is provided by ethnographers and anthropologists, many of whom work as consultants who have built up high levels of practical experience in giving evidence to the Native Title Tribunal. In New Zealand, by contrast, legal tests relate to breaches of principles of the Treaty of Waitangi after 1840. Such breaches are a matter of historical evidence and interpretation, and as a result, specialist historians have played a dominant role as expert witnesses in the Waitangi Tribunal, so a difference here between Australia and New Zealand. The amount of historical research that has been commissioned and presented in New Zealand is extraordinary in terms of its scale and range, and practically every aspect of Maori interactions with settlers and the colonial state have been explored comprehensively, but arguably somewhat narrowly. So, just much more of an influence of the history aspect in New Zealand, at least for the time being, albeit narrow. In New Zealand, the research has been funded generously. Claimants of the Waitangi Tribunal are not required to pay for it themselves. New Zealand historiography is a flourishing state at the present time, partly as a result of the upsurge of primary research generated by the Waitangi Tribunal processes. In Australia, historiography of colonial encounter is a battleground that has become highly politicized. In New Zealand, it is not. Crown and Tribunal in New Zealand can commission historical reports, often longer than PhD theses, and often very bulky. Any jurisdiction that experiments with the New Zealand Tribunal-based model will quickly find judicial and semi-judicial inquiries into Indigenous historical grievances create significant problems with the management of documentary evidence and testimony. So it comes with its problems as well, but I think it's better to do more rather than less, and probably at least New Zealand has put a greater emphasis on the importance of looking at history. Moving to section B of section 4, Retrospective Utopias, titled by the author, Claims Related Research and Writing of History. So the author notes, as bodies such as the Native Title Tribunal or Waitangi Tribunal have become established features of the legal and constitutional order in their respective countries, there has been a growing debate about the historical assumptions that underpin their reports and decisions. A number of writers have suggested that the Waitangi Tribunal's approach to history is presentist, or teleological, or that applies inappropriate or over rigorous canons of behaviors to government actions in the past. According to W.H. Oliver, one of New Zealand's leading academic historians, the Waitangi Tribunal has constructed a retrospective utopia by applying idealistic standards of the present day to the actions of the colonial regimes of the 19th century. It's an argument that the principles of the treaty is a contemporary construction, one that is essentially meaningless to apply to the actions of government and the officials in the past. Also, Gazelle Burns notes, European perceptions were on the whole monocultural and narrow-minded, one-dimensional pictures of Europeans making little effort to understand competing attitudes among the Pākehā, which are non-Maori New Zealanders. Ultimately leads to good and bad stereotypes, and in many ways the debates over the Waitangi Tribunal historiography simply reflect interpretive debates within the historiography of Western Indigenous encounters generally. So, some pretty harsh criticisms, and left out of account in such historical legal narratives are wider social, environmental, and economic changes which cannot easily be attributed to particular governments or individuals, as they may well be global in nature and to some extent beyond the control of particular states. Frequently, evaluations of governments by reference to legal standards such as fairness, standards of consultation, or the principles of international law. It might be obvious that a massive land loss can generate poverty, but it's harder to demonstrate in a judicial form than it might seem, so it's hard to prove causation. In Maori, the reverse case applies. Maori were poor and marginalized to begin with and sold their land as a result, so even more difficult. It's still clear there are dire consequences, however. The national tribunals are ill-placed to consider international trends as well, so it's kind of difficult because one would need to be a historian, international lawyer, but also a domestic lawyer simultaneously. It's too much for any one person, so there will need to be more collaboration perhaps. And they must also look at parallels, such as with Ireland, in the state of rebellion against the crown in the 17th century is much like in New Zealand in the 1860s. More than the risk of presentism, which can be exaggerated, the historiography generated by the special purpose national tribunals will always be only partial, given the supranational, and global will always be outside its gaze. The real risk of historiography arising from the adjudicative mechanisms is not so much presentism as it is insularity. So I think that's, at least he has me sold. It's not the issue of presentism. It's not applying some retroactive utopia. It's more just perhaps narrow focus, not being able to look at parallel jurisdictions, international laws, trends outside the control of the state. But nonetheless, I think they're doing quite a bit of good work, and I don't think any of that should be neglected. And these are just areas in which perhaps merit could be added. Moving to section 5, conclusions. So the brief survey proceeding that we've covered considered the problem of what it meant by settler societies and is focused on the redress mechanisms of two countries, Australia and New Zealand. In both cases, the establishment of such mechanisms arose out of political and legal conjunctures within each country and owed little to developments in international law. So most of them were led by, despite later saying that we should look at international, the current systems were domestically created. The Waitangi Tribunal in New Zealand and the Native Title Tribunal in Australia have very different functions and utilize different kinds of expert evidence and operate in very different political and constitutional settings. While both bodies require expert evidence, typically provided by non-Indigenous specialist researchers, the required expertise in each is different. Anthropology is larger in Australia, and history is larger in New Zealand. In Australia, Aboriginal people have long been marginalized and comprise only a small percentage of the national population, whereas in New Zealand a significant percentage of the population is Maori, and the relations between the Maori and the state have always been central to national politics. In both countries, however, although specialist tribunals have been established to adjudicate on government-indigenous relations, in neither case do these bodies monopolize legal adjudication in this field. And in both ordinary courts, they have continued to play an important role. As a general conclusion, redress mechanisms such as the Native Title Tribunal and the Waitangi Tribunal cannot be properly understood in the absence of full consideration of the historical, political, and legal contexts that operate in their respective countries. So, absolutely fascinating chapter. This is an area I've always been passionate and fascinated about, and it really opened up my mind, and particularly learning more about these two geographies. So I very much thank Richard P. Boast for this fascinating and wonderful chapter. So to quickly discuss the content of the slide before moving to the chapter by Leora Bilsky and Rachel Klagsbrun. So in terms of the images, in the top right we have the University of Waikato, where he received his Master of Arts, and in the top left we have the Victoria University of Wellington, where he received his Master of Law and as well is currently teaching as a professor. In terms of his position, he is a professor at the institution, the Victoria University of Wellington Faculty of Law. Suggested readings include the Native/Maori Land Court, volumes 1 to 3, which across the 3 volumes cover 1862 to 1953, published by Thomson Reuters in 2013, and the last volume was published in 2019. Next book, and second book, Raupatu, The Confiscation of Maori Land, published by Victoria University Press in 2009. Next and third and last book, Buying the Land, Selling the Land, Governments and Maori Land in the North Islands, 1865 to 1921, published by Victoria University Press in 2008, and not the last book that he's written, because he's been involved in at least 9 that I can count. Areas of expertise include legal history, Maori land and law, Pacific legal studies, comparative law, and property law. In terms of the quotes, first quote, I suggest that what is normally meant by settler societies are societies outside of Europe, which today are largely products of 19th century migration from Europe, whether from Southern Europe, Argentina, Uruguay, Northern Europe, Canada, Australia, New Zealand, South Africa, or both, United States. Second quote, more than the risk of presentism, which can be exaggerated, the historiography generated by special purpose national tribunals will always be only partial, given that the supranational and global will always be outside its gaze. The risk of a historiography arising from the adjudicative mechanism is not so much presentism as it is insularity. As a general conclusion, redress mechanisms such as the native, this is third and last quote, as a general conclusion, redress mechanisms such as the Native Title Tribunal and the Waitangi Tribunal cannot be properly understood in the absence of a full consideration of the historical, political, and legal context that operate in their respective countries. So once again, thank you very much, Richard P. Boast. This is in the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tolmans. It is in Part 5, Illustrations, Doing Things with Legal History, and it is Chapter 55, Adjudication of Indigenous-Settler Relations. And we'll talk a little bit more about Richard P. Boast in the comparison with Leora Bilsky and Rachel Klagsbrun after covering the latter two's chapter right now. So this is in Section 5 of the Oxford Handbook of Legal History, titled Illustrations, Doing Things with Legal History, and it is Chapter 56, the second from last, Cultural Genocide, Between Law and History. So a quick biography of both the authors. So Leora Bilsky is a professor and director of the Minerva Center for Human Rights at Tel Aviv University Buckman Faculty of Law, where she received her Bachelor of Law cum laude from Hebrew University in 1991, and a Master of Law at the same a Master of Law in 1993, and a JSD in 1995 from Yale Law School, where she was a Fulbright scholar. She clerked for the Honorable Aaron Barak in Israel's Supreme Court, and was a previously visiting professor at the University of Toronto and Amherst College, and fellow in ethics and the professions at Harvard University. He served as editor-in-chief of Political Theory, Journal of Theory and Criticism, and editor of Law's journal Mishpatin Mishpat and the Theoretical Inquiries of Law. She's also the author of Transformative Justice, Israeli Identity on Trial, published by the Michigan University Press in 2004, and The Holocaust, Corporations and the Law, published by the Michigan University Press in 2017. The biography of Rachel Klagsbrun. She received her Bachelor of Law from Tel Aviv University in 2003. She has a Master of Law in International and European Law from the Utrecht University in 2005 in the Netherlands. She practiced and interned in commercial law firms Yossi Abraham Arad and Co. And she is currently the executive director of the Minerva Center for Human Rights at Tel Aviv University Buckman Faculty of Law, working with Leora Bilsky. And she also does research and development for Partners & Co. And she's also a product manager in legal for Verbit AI, which is a legal technology company. So, without further ado, we will continue to the chapter by them titled Cultural Genocide Between Law and History in Part 5, Illustrations, Doing Things with Legal History, Chapter 56 of the Oxford Handbook of Legal History. So they note here with a star that this essay grew out of a research project on the history of cultural genocide. For a comprehensive and extended elaboration of their findings, see L. Bilsky, R. Klagsbrun, The Return of Cultural Genocide, published in the European Journal of International Law in 2018. So, the author's note, today when one thinks of the term cultural genocide, the immediate thought is of indigenous peoples, whose culture has been erased over decades and centuries by white colonial settlers. Immediate suspects are Canada, Australia, and South America. Particular wrong adds to other wrongs wrought by the West, North, and East, South, and is part of the continuous discourse ever since decolonization started, about the history of colonization. Specifically, this wrong is claimed by survivors of colonization practices who term the disappearance of their cultures and language cultural genocide. Yet as a legal claim, it's still a contentious one. Discussion that ensued during the debates around the drafting of the UN Declaration of the Rights of Indigenous People, UNDRIP, often referred to, in 2007, is a case in point. A draft article that included the thorny words was eventually amended to exclude them, so cultural genocide was amended to be excluded. Arguments were legal in nature, mainly claiming that such a term was not defined in international law. So I didn't know that it was amended to have that term removed. So, and I'd heard many things discussed relating to the UN Declaration of Indigenous Peoples. So it's not that they don't want to defend the cultural genocide per se, but just that it's not defined, supposedly, in international law. This chapter sets out here to depict in broad brushstrokes the development of the term cultural genocide, its connection to the term genocide, and what this can teach us about the relationship between law and history. It's a puzzle that the crime of genocide posits. In a nutshell is this: how is it that crime was originally designed to deal with a new historical occurrence, a systemic attempt to completely erase a cultural group, turned from an encompassing concept of genocide to one limited to physical and biological aspects? So when did this separation occur? Or why did it occur, rather? And how was the cultural essence of, or rather, why did they separate, but why is there a focus solely on physical or biological aspects? And additionally, how was the cultural essence of genocide reduced to an attack on cultural heritage and then detached from the international crime of genocide and relegated to the human rights and minority law under the control of the nation-states? To answer this puzzle, the chapter lets go of the binary approach, positing law and history opposite each other. So, if there's anything that can be taken away from the Oxford Handbook of Legal History, is that by using history, it greatly ameliorates our processes, our research in law. First, it adopts an approach that sees the plurality in law, litigation, legislation, and international and national conventions. This pluralistic view allows us to deviate from the conventional understanding that sees history as a complex and flexible discipline, one that can study long-term processes, take account of the myriad of motives, and go beyond the legal definitions of protected groups to account for the hybrid groups as opposed to law, which is regarded as rigid, doctrinal, and procedural. For these reasons, law restricts the crime of genocide to the most serious acts and by that limits genocide to the physical and biological aspects, requiring a special intent or a plan directed at the destruction of a group as such and affording protection to only limited classes or groups. Instead, authors examine dialectics between law and history to show occasions when law becomes the main tool to address a new historical phenomenon and those times in which laws, categories, and doctrines obscure the novelty in history and force new practices into familiar boxes. The chapter adopts a critical approach to law, one that brings the political dimensions to the center of discourse and claims we cannot understand the tension between law and history as one detached from politics. So not only do we need to combine law with history, we also have to combine law with history. If I had a third hand, I would put politics in there as well. Conversely, claims that politics alone without understanding the precedents of legal doctrines or historical traditions and methodologies cannot explain the transformations in the meaning of genocide. So evidently you can't also just look at politics as well. And also just to note, this chapter is also not divided into sections, so I'll try to give it some sort of structure if possible. Prior to the involvement of states in their political considerations, it was mostly an endeavor, according to the author, of one man, Raphael Lemkin, that gave rise to the idea of genocide in the first place. So kind of, I guess, we'll start off with the background of cultural, or genocide itself. And what influenced Lemkin in devising his theory of genocide is the subject of many historical legal researches. Among other influences, writers have identified the Armenian genocide, the South American conquistadors, the Zionist movement, and the trial of Shalom Schwarzbad, his academic work as a comparative criminal lawyer, and his own personal experiences during World War II as leading factors behind sort of how he created the idea of genocide. For authors, what is missing in this debate about the origins of Lemkin's concept of genocide is a discussion of the method he employed in identifying and mapping the new historical phenomenon. It refers to Lemkin's rigorous collection of legislation, orders, decrees, and laws enacted by Nazis in every country they have occupied, which later became the basis of his book Axis Rule in Occupied Europe, 1944. So actually published before the official end of the World War II. This method authors term as legal philology and allowed Lemkin to expose the grand plan of the Nazis, not just in physical annihilation of individuals and long before such was executed, but a systemic and holistic dispossession of entire groups through legislation that applies to every aspect of life, from the right to freely use trams or parks to the right to possess real estate and other property, from the right to employ Aryan help to the right to freely marry or to have intimate relations, from the obligations to wear a yellow star to the obligation to add the name Sarah to one's identity card. By collecting and amassing these decrees one by one, Lemkin came to realize the depth of the Nazi plan and how it had targeted groups, and understood that people were not persecuted because of any individual trait they may have, other than their belonging to a certain group that was a target of persecution. The ingenuity of this approach, explains Philip Sands accordingly, lies in the piecemeal method. Individuality, each decree looked innocuous, but when they were taken together, examined across borders, a broader purpose is emerged. So something that's very important in law is to look at what is the reason of the law, and part of it is looking at whoever came up with the idea, what were they looking at. So looking at Lemkin, is he was actually sifting through Nazi decrees and such and orders, and noted that it was a piecemeal approach. It wasn't all sort of one big document saying this is how the genocide of the Jewish people during World War II should be done. It was many little things that culminated in the genocide. So that's something, the key takeaway to keep in the back of one's head as we continue through this chapter. For Lemkin, what was most disturbing was the way Nazis sought to destroy these groups' cultures. By enforcing a Nazi curriculum to the exclusion of local or liberal ones, and by destroying synagogues and confiscating libraries, culture, the glue that keeps group together, was being destroyed, and this led to the destruction of the group. So it's not only the physical. It wasn't just that there was murder and all kinds of other atrocities. There was also cultural destruction that also formed a part of the genocide, according to the authors. And this need not necessarily be accomplished with physical destruction, although in the case of the Holocaust it was, but as opposed to the current understanding of the term physical and cultural genocide as different types of genocide. Lemkin saw all the varied ways in which Nazis employed their plan as techniques of genocide. In his book, he enumerated 8 of these techniques: political, social, cultural, economic, biological, physical, religious, and moral. So there are many different forms of genocide, and these are not degrees of genocide. They're all they're all individually sufficient. For Lemkin, the cultural technique was as bad as any other. It was an aim in itself, not a byproduct of another technique. So it cannot be separated. One can just focus on cultural genocide, and it is still genocide. Another important aspect of this position is that these techniques are what differentiates between genocide and mass murder. Following Lemkin, one can say that if the phenomenon could be reduced to mass murder, a new crime would not have to be defined, as such a crime is already prohibited by national and international legislation, and the only problem it presents is jurisdictional, owing to state immunity. So, if genocide is only physical, then is it not just mass murder, and is it not just a domestic issue? This problem can be solved by creating international or universal jurisdiction to adjudicate such a crime and does not necessitate the definition of a new crime. But if one understands the crime as targeting a group as such, then the protected value is different and a different solution is called for. Another important aspect Lemkin learned from his meticulous work was that genocide has two stages, a negative one, which is the destruction and annihilation of the group inhabiting a conquered land, and a positive one, which is the imposition of the national pattern of the oppressor on the oppressed people, which is sort of like the residential school system in Canada, if they are worthy of it, of their land, according to the authors. This analysis led him to see the insufficiency of law as it stood at the time, and to a large extent as it stands today. This is the first moment in our account where we meet law as a limiting, obscuring force that lacks the adequate tools to catch new historical phenomenon because of its rigid distinctions. International law very much is a statist project, and states are immune from intervening in their internal affairs, and international humanitarian law was manifestly lacking in its treatment, as the Hague regulations only protect individuals and not groups, and do so only during wartime. So international law is in many ways limited, and has been limited. Civilians attacked in their own states are left unprotected. Moreover, war crimes approach favors a discrete approach that prohibits certain crimes without presenting the link between them. What Lemkin saw as the essence of the crime was left untreated by current legal protection. We see in the discovery of genocide, law played a dual role, both in its aiding tool in revealing a crime, which is legal philology, and as a limiting and obscuring factor, i.e. the statist bias of international law. For the former, what is interesting, according to the authors, for us in terms of understanding the link between law and history is the fact that Lemkin developed his sophisticated understanding of genocide mostly by studying legal documents, without having access to minutes of secret meetings or the subjective states of the minds of the leaders. So even further detail would be valuable, but even just by looking at their orders, it does seem that they're targeting many different things. But law itself reveals the system, because the system needs the law in order to operate. So it is sufficient, perhaps. Since the target is a group, and since every aspect of group life is affected, and a coordination must be achieved between all arms of government and private sectors to create a total exclusion, disintegration, and eventually annihilation of a group. So how did genocide and cultural genocide fare in the courtroom? The next stop on our journey will be the International Military Tribunal, the IMT, at Nuremberg. And although Lemkin, as well as Jewish organizations, tried to influence the design and indictment and even suggested a separate trial that prevented a significant change in a specific trial be dedicated to the Jewish Holocaust, eventually the aggressive war paradigm persisted in a way that prevented a significant change in the capacity of law to cope with the new type of criminality that unfolded. Its significance for cultural genocide was that the fact that it required a link to aggressive war through Article 6 of the London Charter, and meant that most of the acts considered by Lemkin to be techniques of genocide were left outside the temporal scope of indictment from 1939 to 1945. And so only the 1939 to 1945 could be within the scope. And so we are left with the legacy of international criminal law that cannot release itself from the legalistic constraints of precedents and criminal law rule of nullum crimen sine lege, which is Latin for no crime without law. Yet law alone cannot explain the difficulty of addressing new historical phenomenon of genocide, because one can find behind the legalists, I always say legalists, I think that's correct, but maybe it's legalists, considerations, a deeper political concern that creating a precedent that will undermine state sovereignty. Such was Robert Jackson's concern regarding interference in a state's internal affairs, for example, the U.S. treatment of its black population. Another factor raised by legal historians to account for the blindness of the trial in relation to genocide is the absence of victims' testimonies from the Nuremberg proceedings, a fact some scholars have connected with the perceived marginality of genocide in Nuremberg. New historical research reveals the many attempts of Jewish organizations to join the process, not only as witnesses but also as prosecutors, amici curia, which is Latin for friends of the court, and as ones that suggested to designate a special crime against the Jewish people, or even dedicating a separate trial to the Holocaust. The underlying assumption of such revisionist history is that the victims participated in the trials in a meaningful way. Genocide would have been taken a more central place. So the argument is that despite these tribunals, there was not enough involvement by the actual victims of the Holocaust. Yet recent historical research reveals a process by which law has gradually grasped the centrality of genocide as the trial progressed and a new evidence was revealed, despite the relative lack of survivor witnesses. So studies suggest that still genocide has been defined despite excluding or not having sufficient representation from the victims of the Holocaust, which are the Jewish, largely the Jewish, but there's also gypsies, homosexuals, and others as well. But for this chapter, we're focusing on particularly the Jewish people here. Such research reveals the Holocaust was not entirely absent from the proceedings. For example, Kim Primel shows that it was very much present in the deliberations as they reflected in the trial sessions transcript, that it influenced sentencing. Lawrence Douglas shows the subsequent trials at the Nuremberg Military Tribunal, the NMY, crimes against humanity was a prevalent category. As the facts of the magnitude of the Nazi criminality unfolded, law was being adapted. The Control Council Law No. 10 served the link to aggressive war and provided a more comprehensive definition of crimes against humanity than the London Charter, so expanding its scope. Regarding cultural genocide in Nuremberg, Alexis Stiller studied the NMT and specifically the Race and Settlement Main Office of the SS, which is the Ras- und Siedlungsschaubeamt der SS, or the RU-SHA trial. She shows the prosecution was well aware of Lemkin's theory, quoted from his book, and specifically dedicated the trial to the positive aspect of genocide, positing it as complementary to the IMT, which dealt with the negative aspect. So the IMT covered the negative aspect, and then they drew from Lemkin for the positive aspect. Yet these efforts did not bear the hoped fruit. The judges were not persuaded that the crime of genocide was indeed part of international law, and hence did not use it as a legal category. So a big setback for this, if one believes genocide should be relevant in international law. Indeed, they particularized the Germanization plan into discrete war crimes. Likewise, the mass murder of Jews underwent decontextualization from a broad Nazi policy executed in stages by various techniques to narrow perceptions of murder only perpetrated by SS men. So it sort of narrowed it, sort of getting rid of the cultural and stuff just to the particularly the violence, and particularly by the most violent people. Again, the available legal tools and legal imagination were inadequate to capture the realities of the atrocities that pervaded Europe only a few years prior. So this is this is Nuremberg, this is right after the war, and they're still neglecting many aspects. So therefore the authors ask, was the fact that almost no Jewish survivors testified at the IMT a decisive factor in the tribunal's comprehension in the essence of the genocide of mass murder? So is this that cause? So, historians believe the tribunal was not disposed to hearing testimonies about the cultural destruction that befell European Jewry. That is Jewry. This is especially evident in the that is in Jew, not jury. This is especially evident in the testimony of one of the only Jewish survivors who survivors who were summoned by the Russian prosecution to give testimony. So only the Russian prosecution brought any Jewish survivors to the testimony, which I find rather strange and a clear blind spot. Abraham Sutskever was a famous Jewish Lithuanian Yiddish poet who lost most of his family. Also had a central role in the efforts, but despite this unique role in relation to the Jewish cultural genocide, Sutskever's testimony focused on the collective murder and was not asked about cultural destruction nor his efforts in cultural rescue. One remote echo for the cultural side of the genocide appeared in Sutskever's request to testify in Yiddish, the language of most murdered Jewish victims. The request was denied as Yiddish was not one of the four official languages of the trial, and hence no translator for the language was available. So I think that is, I did not ever know about this. That is really quite crazy to me that they could not have the trial translated into Yiddish for this Yiddish speaker Sutskever, which is the language of most murdered Jewish victims at the IMT, the International Military Tribunal in Nuremberg. That is absolutely crazy for me. After all the Jewish people had gone through, they couldn't get a translation at their own trial. I think is wild. And once again, so there was very few Jewish people at the trial to give testimony. The Russians were the only ones who really brought them. And then with Sutskever, who was one, the questions neglected any cultural aspect. So I think it was really quite, at least on these points, quite as many failures. The IMT and MT, that's the Nuremberg Military Tribunal as opposed to the International Military Tribunal, were not the only trials that dealt with the Nazi atrocities. Soon after the war, Poland established a tribunal to judge major Nazi criminals active in Poland during the occupation in accordance with international and Polish criminal law. Being a national tribunal of persecuted group, it was much more sensitive to the cultural destruction of Germanization that set upon Poland and the Polish population. Auschwitz is in Poland, for example. This was manifested in the trial of Gauleiter Arthur Kreiser, where the tribunal found the German occupation in Poland was manifested, among other things, in religious and cultural representation. So here we're starting to get some cultural repression or cultural genocide, and they were both termed genocidal and found to be part of the Germanization of Poland. Moreover, both negative and positive aspects of the Nazi persecution were considered by the tribunal following Lemkin's structural analysis of the crime, and we see that in this case cultural genocide came to the fore, inter alia, due to the willingness of the court to hear survivor witnesses, to introduce historians as expert witnesses, expanding the narrow understanding of eyewitnesses, and adopting Lemkin's theory of genocide, notwithstanding the official mandate to investigate war crimes. Again, not only law and history played a role in the revealing cultural genocide, but in no small account also the political will of the Polish authorities. So there's that third leg where we need the political will as well, which was for some reason quite absent in Nuremberg. So the authors then ask, can we assume then that the national courts of victims groups are more favorable towards the prosecution of cultural genocide? Not necessarily so, according to the authors. Another famous national trial was that of Adolf Eichmann in 1961 in Israel. Although there too the trial was conducted by a victim group and the testimonies of survivors were given center stage, the narrative that came out of the trial was very different. To understand that we needed to listen to the voices that were not heard and the voices that were heard but were dismissed and forgotten. The poet Abraham Sutskever, previously mentioned, whom we met as a witness at Nuremberg, was not called to the stand at the Eichmann trial, although by the time he was already moved to Israel. So why were they not speaking to this previous witness? He would have been a clear resource. And historian Salo Baron of Columbia University testified at length as expert historian, but his rather long testimony is not etched into the collective memory of the trial. So even when expert witness, Columbia University, very prestigious university, they sort of neglected his long testimony. Rather, Auerbach, a prominent figure among survivors, testified to the cultural destruction and cultural and spiritual resistance at the Warsaw Ghetto, but her testimony too did not resonate in the judgment of collective memory of the trial. Is common to these three individuals that can explain such forgetfulness? So why was there all this forgetfulness? The authors claim their prominence in the domain of cultural salvage and rejuvenation made them less attractive in the eyes of the Israeli prosecution. The latter had a very clear view of the trajectory of the story, which can be summarized in the motto Misoa Letkuma, which is the Holocaust to Revival story, a narrative centered on the importance of the establishment of the State of Israel, and the trial emphasized the physical aspects of both parts, physical genocide and military resistance. So once again, looking at the purpose or the political will, so they wanted to establish the State of Israel, so they focused on physical aspects. Apart from this cultural salvage efforts during and after the war, in Israel, Sutzkever was a leading Yiddish poet and publicist. To him, the fact that Yiddish was absent from the trial, the proceedings were not simultaneously translated into the language that many of the survivors and families and victims spoke, was a lamentable fact, and I find so too, as he saw that Yiddish itself was another victim of the Nazis. So there was the persecution of their language, and then even at the trial, it's mind-blowing that nobody really brought this up or pushed on this point. And this is, as well as the marginal place for the cultural genocide in the trial, was criticized other survivors as well. So I find that absolutely mind-boggling. Professor Barron, who testified at length in the destruction of Jewry in Europe, tried also to convey the enormous cultural destruction, libraries and collections that were compiled throughout many generations, erased with one throwing of a torch. To him, genocide was not less cultural than physical, and revival too needs to be archived on both places. In his testimony, Barron tried again and again to bring up cultural genocide and referred to the organized Jewish campaign for cultural restitution and reconstruction. By doing so, he produced a subversive narrative of the Jewish genocide in competition with that promoted by the prosecution. As for him, revival could also be achieved outside Israel. Significantly, one of the only times he mentions the term genocide is in reference to the plunder of Jewish libraries for the purpose of scientifically proving their inferiority. Another fascinating testimony, according to authors, was given by Rash Auerbach, a prominent figure among survivors who had dedicated her life to recording testimonies from the Holocaust. In fact, she had already begun this enterprise during the war in the Warsaw Ghetto and continued it after in Yad Vashem, which is the Central Holocaust Memorial Institute in Israel, which I believe I have been to. Auerbach, a journalist, was a careful observant of Jewish life in Warsaw in the 1920s until after the war. This span allowed her witness first the vibrant and rich Jewish life that existed in Warsaw prior to the war, and then the Nazi attempts to obliterate. So that is something that must be noted, that one should have a before and after picture, but I think it's just looking at the after picture, it's clear that it must have been better, because the after picture looked pretty horrible. Her testimony offers a shrewd understanding of the goal the Nazis had tried to achieve by issuing edicts of prohibiting religious, educational, and cultural activities, coinciding with the administrative and economic restrictions designated to cut us off from all sorts of livelihood they wanted to break us from the spiritual point of view. This understanding shares with Lemkin's holistic notion of genocide. Once again, a quote, "This was also a prelude to the physical destruction, to humiliate us and convince their own people and the world at large that this was a nation of parasites who were not fit to live in this world, that they were a kind of gypsies," which I think is, in that quote, a little derogatory to gypsies, but nonetheless, it's the point takeaway here is that they targeted the culture first. Auerbach also testified at length to the creative activities that were happening in the ghetto, in which he played an active role despite prohibitions, and probably with an urgency owing to them. So perhaps they were even doing more art because of that. And during her testimony, the prosecution did relate to these activities as keeping them together in the souls of the Jews. So, I can't forget the study, but for example, if you take something away, and then you give it back, and then it has an effect, then you can, in isolation, see that it has an effect. So there was these prohibitions, and then they did art, and it had a positive cultural aspect. In isolation, one can see that it does have an effect. inconceivable acts of heroism performed by ghetto fighters and those who mutinied in the camps and by Jewish partisans. One wonders whether this extends also to the activities of spiritual resistance in the kind Auerbach described, which she views as equal to the military resistance and an important countermeasure to cultural genocide. So cultural resistance is just as important as physical resistance, according to the authors, or according to Auerbach at least. Thus, according to the authors, we see that although the occasion for highlighting cultural genocide was present in the Eichmann trial, it was nevertheless marginalized because it did not fit the hegemonic ideological perception advanced by the trial, the political aspect. Perhaps the fact that the crime against the Jewish people, which Eichmann was indicted of, was based on the model of the Convention of the Prevention of and Punishment of the Crime of Genocide, was a factor in the prosecution's ignorance of cultural genocide, although it is important to mention that the Israeli law was broader than the Convention in respect to cultural genocide and included subsections 5, forcibly transferring Jewish children to another national religious group, and 6, destroying or desecrating Jewish religious cultural assets or values. So outside this trial, they do have recognition of some cultural genocide or some cultural harms. Yet Eichmann was not charged with any of these. The Genocide Convention, in its final form, presents only an echo of the attempt to include cultural genocide, such as the prohibition of forcibly transferring children to another group, which is Article 2, Paragraph E. Yet cultural genocide was the subject of several debates during the drafting of the convention. This is no surprise, as Lemkin was appointed as one of the 3 experts to help design the convention, not only because what was for him a disappointing outcome of the IMT, Lemkin was also believed that a concerted international effort was needed in order to prevent the destruction of groups. Loyal to his view, he endorsed the inclusion of cultural genocide as one technique of destroying a group among others. But his position was opposed to from the beginning, first by the other 2 experts who opined that what later became a recurrent theme in the objection to the exclusion of cultural genocide in the treaty to prevent genocide. And cultural genocide is an undue extension of pure genocide and was not an attempt to revive the failed pre-war minorities protection regime. Cultural genocide nevertheless entered the draft they proposed, and together with 7 techniques enumerated by Lemkin, grouped under 3 categories: physical, causing death; biological, preventing births; and cultural, destroying a group's specific characteristics. A later draft devoted a separate article to cultural genocide, and this draft was debated and voted by the 6th Committee of the UNGA, the United Nations General Assembly. These debates show a clear chasm between supporters of the inclusion and objectors, and although the claims were cloaked with legalist arguments, the fault line between these 2 groups lies very much in the path of the historical experience of the countries these delegates represented. In supporters groups, we can find the delegates of Czechoslovakia and Pakistan, whose arguments were that a group can be destroyed by destroying its cultural foundations. So these 2 countries do have some experience with that, or significant experience with that rather, or even that they were not physical and cultural genocide intrinsically linked. Cultural genocide was the aim, whereas physical genocide was the means. So that's even taking it a step further, that physical genocide is the means to cultural genocide rather than vice versa, or rather than cultural genocide doesn't even exist. The argument of the objecting delegates reveal their fear that actions that the states routinely do not see as perfectly benign and required, such as the assimilation practices, even forced ones, of minorities or indigenous groups living within their territory, or efforts made overseas in colonies, can be captured by the convention and regarded as criminal. So perhaps there's some malicious intent by some of the states, according to the authors, supposedly, is alluded to here. No specific states are mentioned, however. Eventually the article fell, with the formal reasoning that the Genocide Convention was not the adequate instrument. Instead, the instrument dedicated to protection of human rights, for example, the protection of language, religion, and culture under the Universal Declaration of Human Rights, or the respective national, constitutional, and criminal legislation protecting national minorities, are more suitable, accordingly. This brought an end to the effort to establish an international criminal prohibition of cultural genocide. For us, what is fascinating about this endeavor is the way this exclusion shapes our understanding of genocide as we know it today. Genocide is a plan of rogue authoritarian regime to exterminate a group within its control. Actions taken by a democratic state within its border or in its colonies which do not amount to systemic killing but nevertheless destroy whole groups do not amount to genocide, and the legal treatment, if any, is left to other instruments. So, if there's no deaths, accordingly, it's not genocide, which is, according to these authors, and I do agree, I think wrong. There should be some sort of cultural genocide. When, by killing a culture, you can't kill a people. Where law today can nevertheless find treatment of cultural destruction, authors ask, where can law today nevertheless find treatment of cultural destruction? Cultural destruction can be prosecuted as a war crime in and of itself, as we see in the International Criminal Court's Al-Mahdi case. I interned at the International Criminal Court. Al-Mahdi was before me, but nevertheless a very important case, and it can serve as an evidentiary tool to prove the special intent needed to commit genocide in international criminal law trials. Current international law also allows for compensation through the system of the International Criminal Court. Article 75 of the Rome Statute envisions compensation to victims, and Article 79 establishes a trust fund for victims whose mandate is inter alia, which means among others in Latin, to implement court-ordered reparations. Yet earlier exclusions of cultural genocide mean that compensation, if given, will be limited to physical genocide. So many important takeaways here. Did read the Rome Statute cover to cover, and I did come across both Articles 75 and 79, and the reparations have been given out. But the question here the authors pose is, shall we be applying it to cultural genocide as well? I personally do think so. So moving to the conclusion. So there were no sections previously, but there is a section for the conclusion. So the authors note this chapter explored relations between law and history by following transformations in concept of cultural genocide in a period of its inception during the 1940s. While many claim the difficulty to understand varied histories of genocide comes from a definitionalist approach that tries to fit the historical case to a strict legal definition, it points to the creative potential of the law and how it is initially used to understand the novelty of genocide and the crime targeting a group. The chapter showed both at Nuremberg and during the convention deliberations the struggle was simultaneously an attempt to recognize a new crime and also to keep it in strict boundaries so it will not be used to review discriminatory policies of democratic states against democratic minorities and indigenous peoples. Since the concept of cultural genocide undermined the clear distinction between authoritarian and democratic states, it is no wonder opposition to its inclusion both in Nuremberg trial and the convention was very strong. Yet when the victim group managed to conduct criminal domestic trials, there was more room for cultural genocide. Thus the mention must be made of a recent case argued before the International Criminal Court that demonstrates the continuous struggles to recognize cultural genocide. In September of 2016, the International Criminal Court rendered its first verdict that dealt entirely with cultural destruction. In the Prosecutor versus Al-Mahdi, previously mentioned, decision was lauded for its recognition of the link between attack on a group's culture and its destruction and for precedential value of such recognition in international criminal law. As one commentator noticed, the courts have been slow to recognize this, but there is a clear link between crimes committed against a people and attacks on their cultural heritage. Yet in doing so, the court did not invoke the crime of genocide that deals with the destruction of groups and indicted the accused for the more limited war crime of destruction of cultural property. So they were not tried with cultural genocide, but rather destruction of cultural property, which is quite evidently less. We therefore find that despite growing public recognition in the importance of prohibition of cultural genocide, for instance in relation to wars in Iraq and Syria, as struggles of indigenous peoples to recognize their cultural genocide, the law is struggling to adjust itself to deal with the historical phenomenon of cultural genocide. Furthermore, lately the process for compensation in the Al-Mahdi case has started. 135 applications for reparations were submitted, and 2 documents of observations have been filed, one by the Fédération Internationale des Langues des Droits de l'Homme and Association Malienne des Droits de l'Homme, and others by the defense. Former points to the vast array of victims, starting from the mausoleums, guardians, families, and extending to the people of Mali, and discusses materials as well as mental harm, referring to the point made by the chamber regarding the bond between the people of Timbuktu and its mausoleums. So the Canadian judge who I very much admire, Kimberly Prost, is currently working on a case as well in Mali. And I got to watch very much of that trial, but it was a different trial, not the Almaty case. But nonetheless, that does lead to the question, so if we are focusing on cultural aspects, is everyone a victim? Who do the reparations go to? Who is somebody a greater victim? Are older people greater victims? Younger people greater victims? Are people closer to the... It's harder to define than physical damage. The defense's document lays down the principles of reparations, pointed to the fact that the attacked mausoleums neither had their own legal personality, nor were they property determined natural persons. So, can we treat mausoleums as persons? Evidently not here. And that Mr. Almaty's liability and capacity cannot be measured against those of a state, eventually asking that collective reparations shall be made. We see in both an attempt to view cultural property as intrinsic to the group's self-perception and central to its identity. In the first document, as well as the recent demonstration of the reparations GA in international criminal law, the fact that the buildings were ruined are also valuable in the common heritage of mankind is evident in the restoration work through UNESCO. So perhaps if it's got cultural value, then maybe it does have some kind of identity. In August 2017, the International Criminal Court rendered its reparations order in this case, and appears to be an understanding by the court that protection of culture is intrinsically linked to the protection of groups. So, great job to the International Criminal Court, as the court favors collectivist compensation over individual ones. Two main factors hinder the court's action. First, the indictment was for war crimes, not genocide, and second, that the Rome Statutes framework is an individualistic one. Moreover, criminal and not civil law. Thus, the court devised a dual model by which direct victims who suffered exclusive harm, such as those whose livelihood exclusively depended on the buildings or those whose ancestry was buried in the destroyed graves, are entitled to individual compensation. As to other victims whose claims the court has accepted as belonging to the wider circles of harm, the court ordered that they should collectively be compensated. Therefore, in this recent case, it has revealed how almost 70 years after the adoption of the Genocide Convention, international law is still struggling with the concept of cultural genocide, trying to fit into the available rubrics of state, individual, and humanity. Lost is the earlier understanding of the need to recognize the cultural group or of the heritage community by allowing for more participatory model of engaging the persecuted group in the struggle to bridge the gap between law and history. So, absolutely wonderful, eye-opening chapter, even after just finishing an internship at the International Criminal Court. Some of these things I had not thought of in that way, such as individual reparations and group reparations based on, for example, physical harm and cultural harm, respectively. Very, very fascinating. So, thank you very much, Leora Bilsky and Rachel Klagsbrun. So, to quickly go over the content in the slide, the position of Leora Bilsky is Professor and Director of the Minerva Center for Human Rights at the institution, the Tel Aviv University Buckman Faculty of Law. As for Rachel Klagsbrun, she's a product manager in legal at Verbit AI, but she's also a director at the Minerva Center for Human Rights with Leora Bilsky. As for the images, in the bottom right, we have, for Leora Bilsky, we have the Hebrew University, where she received her Bachelor of Law, summa cum laude. In the bottom middle, for Leora Bilsky, we have Yale Law School, where she received her Master of Law and her Doctor of Judicial Sciences. And in the bottom left, we have the symbol of the Tel Aviv University, where she teaches as a professor and director of the Minerva Center of Human Rights at the Buckman Faculty of Law. For Rachel Klagsbrun, in the bottom right, we have the Tel Aviv University, where she graduated with her Bachelor of Law from the Buckman Faculty of Law. And in the bottom left, we have the symbol of Utrecht University, where she received her Master of Law in the Netherlands. As for suggested readings, we have by Leora Bilsky, The Holocaust, Corporations, and the Law, published by the Michigan University Press in 2017. Again, by Leora Bilsky, Transformative Justice, Israeli Identity on Trial, published by the Michigan University Press in 2004. And then published by both of them, Leora Bilsky and Rachel Klagsbrun, Return of Cultural Genocide, published in the European Journal of International Law, volume 29, published in 2018. As for the three quotes, first quote we have, or pardon me, two quotes. Well, maybe we'll do the research interests. And these are research interests particularly pertain to Leora Bilsky because she is currently a professor, so she does have a web page that lists this, but I don't think these are mutually exclusive. I don't think Rachel Klagsbrun is not interested in these areas, but she might have different ones in some cases, but most of them, hence sharing the chapter, are quite similar. So research interests include law after the Holocaust, political trials, transitional justice, international criminal law, feminist legal theory, and relationship between law, history, and memory. So first of two quotes. Today, when one thinks of the term cultural genocide, the immediate thought is of indigenous peoples whose culture has been erased over decades and centuries by white colonial settlers. Immediate suspects are Canada, Australia, and South America. This particular wrong adds to other wrongs wrought by the West/North and the East and South, and is part of the continuous discourse even since decolonization started about the history of colonization. Second quote. While many claim that the difficulty to understand the varied histories of genocide comes from a definitionalist approach that tries to fit the historical case to a strict legal definition, it points to the creative potential of the law and how it was initially used to understand the novelty of genocide as a crime targeting a group. So, thank you very much, Leora Bilsky and Rachel Klagsbrun. This is Chapter 56 of the Oxford Handbook of Legal History, titled Cultural Genocide Between Law and History, and is in Section 5, Illustrations, Doing Things with Legal History. So very, very fascinating chapter, and thank you for sharing this. So, in terms of a brief comparison between the three, which is uncommon in the style of Plutarch's Lives, but nonetheless must be done for parallelism across this series. So Richard P. Boast, in terms of the roles, Richard P. Boast is a professor. Leora Bilsky is a professor and director of the Minerva Center. Rachel Klagsbrun is a product manager in legal for Verbit AI. So she's also a director of the Minerva Center, but nonetheless she's one of the maybe an outlier in the Oxford Handbook of Legal History that she's not currently a professor. As well, so Richard P. Boast is a professor at the Victoria University of Wellington, so in New Zealand, whereas Leora Bilsky and Rachel Klagsbrun, I believe, are both based in Israel, but at least they both have a pretty strong affiliation with the Tel Aviv University Buckman Faculty of Law, so very different regions geographically. In terms of their degrees, they all have an LLB from Victoria University of Wellington, Hebrew University, and Buckman Faculty of Law, respectively. The Richard P. Boast has a Master of Arts and a Master of Law. Pardon me, he has a Master of Law from the Victoria University of Wellington. It didn't list a Bachelor of Law, but I assume he did it at the same institution. Whereas Leora Bilsky and Rachel Klagsbrun also have LLMs at Yale and Utrecht, respectively. So different geographies very much there. So Rachel Klagsbrun does have a experience in Europe, and Leora Bilsky has experience in the United States, whereas Richard P. Boast has predominantly in New Zealand. In terms of some awards, Richard P. Boast has received the Officer of the New Zealand Order of Merit and King's Counsel. When he received it, it was Queen's Counsel, but it's now King's Counsel. And he's also a member of the panel for the Attorney General to review Foreshore Seabed Act. Leora Bilsky was a Fulbright Scholar at Yale. Rachel Klagsbrun has also won many awards too. However, some of them are harder to find just because she does not have a professor website. But nonetheless, they're all very high achieving, but in different areas. Whereas Richard P. Boast seems a little bit more experience in practice, but Rachel Klagsbrun actually works for a private company. Whereas Leora Bilsky has probably predominantly spent most of her time in academia. However, she clerked for the Honorable Aaron Barak. Whereas Richard P. Boast has much experience in court as well, such as a practice as barrister in a period before the Maori Land Court and the Waitangi Tribunal as counsel and a historical witness. So I think he's writing about it because he's been there. Richard P. Boast knows Spanish, French, and Portuguese. Leora Bilsky both definitely know English, but perhaps they also know maybe some Hebrew, maybe even some Yiddish too, at least because of their areas of study. But I would say they're all multilingual, at least. Leora Bilsky also has been a visiting professor at the University of Toronto and at Amherst College, so further experience in North America, which I don't think is necessarily as true for Richard P. Boast and Rachel Klagsbrun. And also in ethics and professions, a fellow ethics and professions at Harvard as well. So Leora Bilsky probably has maybe the most experience in the United States. But nonetheless, they're all sort of spread across the map, but I'd say Leora Bilsky and Rachel Klagsbrun are most centralized in Israel, and Richard B. Boast is most centralized in Oceania, specifically New Zealand. Yeah, they're all very fascinated in legal history. Richard P. Boast does not have a PhD, nor does Rachel Klagsbrun, which isn't necessary to be a legal scholar. A lot of the legal scholars in the Oxford Handbook of Legal History have both a Juris Doctor and a PhD. Some have just a PhD, some have just a Juris Doctor or just a law degree. At least for of these three, Leora Bilsky is the one with a doctorate degree in law from Yale Law School, which is a very, very competitive law school, but they all have graduate degrees, masters, and LLMs. So thank you very much to Richard P. Boast, Leora Bilsky, and Rachel Klagsbrun, and I'll also add Christopher Tollins and Marcus D. Dubber. And thank you very much to you for watching this and continuing to support. Thank you so much.